Welcome to Know Your Rights in New Jersey. On today's episode, we will talk about the basics of driving under the influence with our expert guest, John Menzel. Oh, don't laugh, John. We know you're an expert.
People say I do drunk driving all over the state and drugs, and I defend people that do it too.
Well, thank you for joining us. Let's start with a very simple question, which some people may consider kind of not the smartest question in the world. But you talk a lot to lawyers, you talk to adults, you talk to students. How do you avoid DUI? What do you tell them?
Well, the first thing you do is not drink and drive, but listen, drinking and driving is not an offense in New Jersey. It's only when you drink too much. And the best way to avoid the consequences, I say, although that's not the aim, but you have to understand your constitutional rights. Mm. And you have to understand what the law requires you to do when you're driving a car. Now, when you drive a car, what you have to do is pretty much common sense. You get the signal to pull over, you pull over. You have to have your driving credentials out for the officer. And if he asks for them, you got to give them to him. If he orders you to get out of the car, you get out of the car. If he arrests you, you got to submit peacefully to the arrest. And finally, in New Jersey, if you're asked to blow into the machine, you blow into the machine.
Well, when the officer stops you, is there anything that you should say to him or anything other than what you've explained that you should do?
Well, look, when you're the target of a police investigation, there's nothing you can say that's going to help you. And you have certain fundamental constitutional rights that boil down to two words: silence, attorney. Silence, attorney. And the reason I'm repeating it is because I want you to remember it, because there will be a quiz later on in this episode. But, look, when you get stopped and the cop starts questioning you, most people think it's a choice between lying and telling the truth. And they forget there is a third constitutionally protected choice, and that is not to answer the question.
Well, let's talk about the real perception that some people may have, particularly people of color, when they're stopped by officers. They may feel that silence escalates the situation. Would you still tell them to be silent?
There's nothing you can say when you're the target of a police investigation. There's nothing you can say that's going to help you. So the only thing you say is, officer, I don't want to answer that question. Officer, I have nothing to say about that. Now that's going to generate a response. Whether you're black or white, it's going to generate what you'll perceive as a negative response.
But why? What happens generally in the police officer's perspective?
Here's what happens. First of all, you're going to perceive a stiffening of his posture. You're going to perceive a tightening of his voice, maybe an escalation in pitch, a rapid, increased rapidity in the pace of the speech. You're just going to feel this is not a good thing to do. But if you understand why the cop's reacting that way, it'll make it a lot easier to implement this. You're doing two things to him. First thing you're doing is you're violating his expectations. Because, they give him the gun, the badge, the uniform, the car. He is vested with the authority of the state. And when an officer asks people questions, or even asks them to do balance tests later on, he expects people to do that. He expects answers, and he expects you to do this.
Because his prime objective, or one of his prime objectives, is to control the situation.
Well, that's true. That's true. And when you say, I'm not answering questions, he'll lose control. You're violating that expectation that people do what he wants them to do. And the second thing you're doing to him, he's not asking you these questions to help you. He's looking to build a case against you. You are the target, so we want to generate enough information so that I can justify arresting you without a warrant, and maybe even I'll get enough information to prove one of the elements of the offense. So when you don't do these things like standing on one foot, standing heel to toe, walking heel to toe, following a finger with your eyes, reciting the alphabet, counting backwards, touching your finger to your nose, some cops will even take your pulse or your blood pressure at a certain point. When you don't do those things, You're violating his expectation and frustrating his purpose. When you don't answer his questions, you're violating his expectations and frustrating his purpose. And some cops get aggressive. You know, cops are like anybody else. There's all kinds. They react differently.
Under stress.
A very professional cop, your answer won't faze them at all, and you won't detect anything. But most cops, even professional cops, will be put off initially. They'll ultimately remember that, hey, there's this thing called the Constitution that gives you the right to remain silent and the right to an attorney. And where the right to attorney comes in is when you get a cop whose initial reaction is like, don't lie to me, sir, I can smell it on your breath. What did you have to drink? At that point, you say, look, officer, I'm not lying to you. I don't want to answer any questions, and I want to call my lawyer.
And that's specifically how you exercise those two constitutional
Absolutely,
rights.
and I want you to know, I have field tested my own advice 4 times, and it has worked every time. I've managed not to get myself arrested. So.
Tell us, what is drunk or intoxicated in New Jersey?
Well, there's two definitions, really. One is when your ability to operate your motor vehicle safely is adversely affected. Okay. And that can be very subjective. Okay. You know, people are sometimes pulled over for very minor deviations from the norm. And it could be impairment is a word that prosecutors like, but when you put that word into context, you realize it's not a bad word at all, because you can be impaired by many things having nothing to do with alcohol, like being tired, or when you encounter the police officer, being nervous or distracted by the lights. Maybe you have some physical problem. Maybe you're wearing crappy shoes. Who knows? There's all kinds of things that cause impairment. And
is it personalized?
Well, yeah, everything's done on a case-by-case basis. Mm-hmm. But, listen, when my favorite kind of evidence is video, because it cuts right to the heart. Somebody looks at a video, and you'll have a feeling whether somebody's drunk or whether they're tired, or maybe they're not really impaired at all. That's not to say that you won't get arrested, because at the arrest stage, all they need is something called probable cause. Enough information to justify taking you into custody for the purpose of continuing the investigation. And the continuation of that investigation brings us to your second definition for what being under the influence is, and that is a blood test result. Now, in New Jersey, we define the offense in terms of blood alcohol, but the way that the police measure blood alcohol is indirectly by use of a breath test.
Okay. And that test is called a?
Well, we used to use the Breathalyzer many years ago, and that's kind of moved into the general language. But today we use a device called the Alcotest 7110. Mm-hmm. And it's very interesting how they measure it, but the bottom line is you got to blow.
Before I go to gotta blow, is it accurate?
Oh, by and large, it's probably accurate, but it's not foolproof. Okay. Understand that the premise behind breath testing mm-hmm. is that the amount of alcohol in your lungs is directly related to the amount of alcohol in your blood, okay. because of the close proximity of blood and breath. In other words, all the vapor that's going into that machine mm-hmm. is coming from your lungs. Okay. But there's some people where that assumption just doesn't apply. And one of the most common maladies that people suffer from is something called gastroesophageal reflux disease, chronic heartburn. Right. You know, it's like that little sphincter that keeps the stomach closed, doesn't work right and is open all the time. It's like having an open flue for the chimney. And so when a person blows into an Alcotest device and creates that pressure that causes the vacuum that's directing the breath into the chamber, into the machine, it's also going to draw vapor from the stomach, and that's going to contaminate the sample. That's one reason, by the way, cops are required to watch a person for at least 20 minutes continuously immediately before they blow into the machine, because there may be residual alcohol in the mouth.
So that's why they're out there for such what seems like a long period of time.
Anytime you're under arrest, it seems like a long time.
Okay, so you said you were going to tell us we must take the test. Really? Must we?
Look, you can choose to not take the test, but that choice is fraught with peril. It gives rise to another offense called breath test refusal, refusal to submit a breath sample. And believe it or not, for a first offense, the penalties for breath test refusal are more significant than for the first offense DUI.
Explain.
Well, first DUI with no reading or a reading less than the legal limit, or I should say less than a .10 because the legal limit's .08, 3 months loss of license, among many other significant consequences. First offense refusal, a 7 to 12 month loss of license, followed by a requirement that you have a device called an alcohol ignition interlock installed in your car for at least 6 months and as much as 12 months. Okay. And you can only drive that car. And the interesting thing about that alcohol, that interlock device requirement, it's very discriminatory. It's discriminatory against people who live in more urban areas. It's discriminatory against people who are poor and can't afford a car. Because in New Jersey, the bridge between full revocation and full restoration is this interlock device. You get your license revoked in New Jersey, there's no work license or special license or hardship license. You cannot drive. And if you drive during that period, you're going to lose your license for an extra 1 to 2 years. You're going to go to jail for 10 to 90 days. Your fines are going to be about $1,000, as much as $1,500 in certain cases. For the DUI or the refusal, you got the fines in court, which can be as much as $689, $889. And then there are surcharges and all kinds of fees that you pay to the state. They're going to be a little bit over $4,000. And then your car insurance is going to go through the roof.
Take the test.
Take the test. You know what, even with the DWI, you face very similar consequences, but it's a whole different defense because there may be problems with the equipment that's used to measure the breath sample, with the way the officer did it. Maybe the prosecutor is new and doesn't know how to present the case because so few of these cases get tried.
Right.
And they make mistakes. I mean, I can tell you half the cases I win at trial are because the prosecutor made a mistake.
Take the test and get an attorney.
Correct. Somebody knows what they're doing. You know, one of the problems with the defense of DUI in New Jersey is there are so many attorneys out there that really don't know what they're doing. And they think their job is to hold their client's hand as they plead them guilty. You know, unless a defense jumps up and bites them, that's the advice they give. And I guess it's because they're afraid of looking bad or making a mistake. But if you're a young attorney, it's a great area to practice in because the penalty ranges are so narrow. It's much different than criminal defense in the sense that your downside risk to go to trial is very low. By that I mean the difference between a penalty you would get if you lost after trial versus if you pled guilty up front, it's not that great, and in most cases it's non-existent. So you might as well take the case to trial because you just never know what happens at a trial. Our system is based on the defendant having an absolute right to remain silent, forcing the state to prove guilt beyond a reasonable doubt, and the entire burden of proof is on the state to do that. And people think that's not fair to the state. The state's the one with the money, the one with the power. The fact of the matter is this goes back to England. You know, I know you teach, you're a history buff.
That's right.
What was it the old English prosecutors used to do? If the defendant took the stand, they would say, he'll say anything to get off, he must be lying. And if the defendant chose to remain silent for whatever reason, they would say, well, he must be guilty because if he was innocent, he'd be up there saying how innocent he was. And of course, our founding fathers saw the problem here, and the way they decided to make trials fair was by putting the entire burden of proof on the state, removing any obligation from the defendant to come forward with evidence except in limited circumstances, and to actually remain silent. That's the only way it can be fair, because otherwise, anybody who gets accused has a very high risk of conviction.
John, you are shedding wonderful knowledge. So we will take a break, and I advise you to come back. Welcome back. We're here with John Menzel discussing driving under the influence. John, let's go to the penalties for driving under the influence. What are they?
Well, it's a rather serious offense. There are court-imposed penalties. There are administratively imposed consequences. There are what some people call collateral consequences. But in court for DWI, first offense, up to $889 in fines, a 3-month revocation if your reading is low, 7 to 12 months if it's above a .10. If you're above a .15, alcohol ignition interlock for no less than 6, no more than 12 months. Second offenses go through the roof. You're talking about a 2-year loss of license, 30 days community service, a 1 to 3 year alcohol ignition interlock requirement after the loss of license. The fines go up to $1,389. And there's a mandatory jail term of no less than 2 and no more than 90 days, although typically what they make you do is something called the Intoxicated Driver Resource Center. That applies to a first offense as well. It's 2 6-hour sessions generally for them, but for a second offender, 48 hours overnight. And a third offender, you're looking at 6 months in jail. You're looking at 10 years loss of license, followed by up to 3 years of interlock. And again, the fines are about $1,389.
Okay, John, you have 2 offenses. Your third offense is 7 years out. Is that a new one offense? Do you start over?
Nope. They have a look-back period of 10 years. And the way it works is this. In deciding whether you're a first, second, third, or subsequent offender, a court will look at the number of convictions you have in your lifetime. And you get a step down if there's at least 10 years between your current offense and your last one. Many people will get nailed the first time, go 15, 20 years, they get nailed again. Second offender, but because of the step down, they're treated as a first offender. And then they go less than 10 years, or they just skip right over second offense and go right to third offense. So it's a serious offense, and in addition to what the court does, our administrative agencies get in on the act. We have the...
and makes it financially very difficult.
Well, you have to pay the government between $3,000 and $4,500 in something they call a merit rating plan surcharge. There's other fees. At a minimum, you're looking at about $4,005 at a minimum. Most of that's payable in installments over 3 years, but you're right, it's still a lot of money. Financially, as far as your car insurance goes, you're looking at an increase in your insurance premiums for between 200 and 400%, 2 to 4 times what you're paying when the insurance company finds out, which is usually around the renewal time after you get the conviction. So that, obviously you want to avoid the conviction, but that's a lot of money. And even more important, there's other special consequences depending what you do for a living. For example, commercial driver's license, very significant impact, can lead to loss of your career. If you drive a taxi or a limousine, loss of career. You can't go to Canada because Canada looks at DUI as a crime. It's a crime in Canada. And they have access, when you cross the border, to motor vehicle records, to criminal records. And if they look there and see DUI, even though it's not a crime in New Jersey, they will look at you as a criminal and not let you in the country.
Wow.
So there's a whole bunch of questions you have to ask people.
Now, was that what I interrupted you when you started to talk about administrative? Was that what you were going,
Administrative means the Motor Vehicle Commission, the Bureau of Alcohol Countermeasures, which runs the Intoxicated Driver Resource Center. Mm-hmm. With a second offense, by the way, IDRC as we call it, they have a great deal of power over your driving privilege. They can recommend to a court that if you don't do what they want you to do, which can be pretty significant in some cases, you'll never get your license back. And they're very hard to challenge. In fact, I don't know anybody who's been able to challenge them yet, although I'm going to give it a try.
Okay, so let's move from there because this is daunting. Mm-hmm. And but conviction is not automatic.
No.
You must go to trial or negotiate or plea or whatever.
It's funny you say that because believe it or not, you can't plea bargain DUIs.
You can't plea.
Except in very limited circumstances.
Talk to me.
Well, a DUI refusal?
Yeah.
I can't plea bargain that if you're a first offender, but I can if you're a second or a third. In Virginia, they automatically dismiss the refusal if you get convicted of the DUI because that whole requirement of submitting a sample has served its purpose, but not in New Jersey. So the rare circumstance, I guess if you're a third or subsequent offender and you know you're toast,
That's
maybe refuse. But generally speaking, because you know
so
what?
there is an exception there.
You will never go to jail for a refusal. You may lose your license for 10 years, because you know, for refusals, they not only count prior refusals, they count those prior DUIs as if they're prior refusals.
Oh, wow.
And with the exception of the jail, the penalties for refusal are just as bad as they are for the DUI.
So let's spend some time talking about jury trials.
Okay.
Tell us, first of all, what you're involved in a major case.
Well, there is. We have a case called State versus Dennelsbeck, and the key question in that case is, are the penalties for a third or subsequent DUI offender sufficiently serious so as to give a person a right to a jury trial? Now, normally we just look to see if it's labeled as a crime or in New Jersey, a disorderly persons offense, a felony, or a misdemeanor. But sometimes that's not the best way of doing it. You have to look at the actual penalties that are involved if you get convicted, regardless of the label the legislature puts on it. So the challenge in Dennelsbeck's case was, are the penalties for a third or subsequent DUI offender serious enough to give him the protection of having 12 ordinary citizens act as his judge of the facts? One of the criticisms of our municipal court system in New Jersey is that you're dealing with judges who get a 3-year term, prosecutors who get a 1-year term, and they get appointed at the pleasure of whoever's running the town at the time of reappointment. There's no tenure. They don't have any guarantee of being reappointed. If they make an unpopular decision, they're going to be subject to criticism. And sometimes when people complain, that's the quickest way to not get reappointed.
Right.
And I hate to say it, and I don't mean to say this about all cops, but some cops are big whiners and complainers, and they're organized. And as a result, the basic structure of the municipal court system leads to a certain degree of institutional corruption. Now, I'm not saying judges are corrupt. I'm saying, and I can tell you, in the more than 30 years that I've been doing this, I've seen a great improvement in the quality of the municipal court judiciary, but it is still something that does give us concern. Because frankly, you convict people accused of DUI, you don't get in trouble. Judges, prosecutors have a little bit of a vested interest. You know, prosecutors should. Judges shouldn't. And that's the nice thing about juries. They bring the same biases and prejudices to the fact-finding process as a judge would. But the bottom line is they don't have to worry about getting reappointed or worrying about their paycheck. And as much as many judges will say, I don't want to deal with that, or it doesn't bother me, it still makes you wonder. The other problem you have is jurors are really strangers to the fact-finding process in the sense that they don't know the defendant, they don't know the cops involved, heck, they don't know the judge. But the judges deal with the same cops day in and day out. You know, if a cop's bad and a judge says so, and the judge is well respected, maybe that cop's not on the force. But you get a cop who's there day in and day out, and the judge hears them all the time, and maybe develops some kind of a feeling for them, whether it's positive or negative, it affects the fact-finding process. Mm-hmm. And so that's the strength of juries, is their detachment from the fact-finding process.
Do other states have jury trials on DUIs?
At some level, every state has a jury trial. Every state. Not so much for first or second offenders, but for third or subsequent offenders, every state has a jury trial. In Hawaii, where by statute they say you only get a jury trial with a fourth offense, given the penalties, you still get a jury trial with a third offense. You know, Pennsylvania's an oddball state. It's not a crime, yet you can go to jail for 2 years, so you get a jury trial. So we're now applying to the United States Supreme Court to have them deal with the issue.
Oh, so it's gone through a number of levels, the appeals court here, the Supreme Court here, and you're
We
looking
have
for
exhausted our remedies in New Jersey.
You're on your way.
And I have to tell you, our state Supreme Court did a lot of homework before they came to the wrong decision. Well, they thought about it. I have to give them credit for that. And it was we had one very strong dissent.
Oh, it was a good, strong dissent.
That justice.
What was the dissent generally?
He said that we have crossed the line between petty and serious. You know, they did a similar case called State versus Ham in 1990. almost the same fact pattern, except in New Jersey we have increased the penalties a little bit between 1990 and today. For example, in 1990, a third offender, you might get 6 months in jail, but you could do 30 days inpatient, 60 days outpatient, 90 days community service. Since 2004, you do 6 months in jail, it's 6 months. There's no good time credit, no commutation credit. The joke is you get a minimum of 180 days and a maximum of 6 months. And there is, if you were charged with a third or fourth degree crime, you will likely never do any jail time. You might even get a pretrial diversion from prosecution. And although a $10,000 fine is authorized, it's almost never imposed. Bottom line is if you get convicted of a third or subsequent DUI, you will do 6 months in jail. You will pay $13.89 in fines to the court. You will pay at least $4,005 and maybe a little bit more in administrative fees. And again, you're not going to be driving for 10 years. And even when you can get your license back, you need that breathing device in your car.
Well, I'm going to interrupt you because we're running out of time, and I really want to get to the question of what can happen in a trial that would help a defendant.
Oh. Cross-examination, they call the great engine of truth. And the uneducated will look at a police report and think this guy's dead. But when you put facts into context, what seems like a very damning fact may become something fairly innocuous. And so, absent other evidence to the contrary, most observational evidence can be neutralized to some degree through cross-examination, put into context. And I already mentioned before what happens with breath testing. You may find a problem with breath testing, and through an affirmative defense, which is where the defendant actually can come forward with evidence, you can show how there's a problem. State has to establish a prima facie case. They establish their elements. Once they establish their elements, the defendant has the right to come forward with additional evidence, and there we can challenge it. I already mentioned before, too, prosecutors make mistakes because too few of these cases actually are taken to trial.
So, how does one plead in a DUI?
Generally speaking, there's only one way to plead.
And what is that?
Not guilty.
John, thank you very much. This has been a very, very informative. And thank you for joining us. See you next time.